Today, we're going to be talking about U.S. cannabis, specifically its import and export, including hemp and paraphernalia. Obviously, with the downturn in the cannabis economy, lots of cannabis companies, including ancillary companies that make products and hardware and equipment in this industry, are looking to diversify and expand their markets. One of the ways to do that is going to be through import and export, which is already happening today. The reason why we decided to put on this webinar was because the influx of client inquiries regarding ability to import and export has simply skyrocketed in the past 3 to 4 months, and Vince can talk about that when we get into our panelists. So let's do that now. Today we have Fred Rocafort, who's joining us from Florida. He is a trade lawyer with an IP background. We also have Vince Sliwoski, who is one of my partners out of our Portland, Oregon office. And we have Adam Lee, who's a trade lawyer, joining us from our Seattle office. And today it's going to be very conversational, as these webinars typically are. We got questions ahead of time from the audience. Thanks so much for supplying those. And we'll take your questions as we go through the webinar. And before we jump into the substantive aspects of today's talk, just want you guys to know that more than 300 of you registered. It's typically legal executives, compliance teams that are listening today, even some government regulators. And we've got multiple countries in the house, including Canada, Mexico, Ecuador, Colombia, Israel, France, Puerto Rico, the Philippines, Spain, Thailand, Portugal, and South Africa, just to name a few. So there's a lot of interest in this topic, and we're so glad that you're joining us. At the top, let's just go through the basics that I'm going to cover as the moderator, essentially the current status of cannabis in the United States under the Controlled Substances Act. Despite the fact that we have more than half the states now that have some form of medical or adult use reform and laws in the books, cannabis remains a Schedule I controlled substance under federal law pursuant to the Controlled Substances Act. It essentially means that it's got a high degree of abuse and literally no medical value. And our federal government seems to have no appetite for changing that status anytime soon, although the current executive administration is flirting with some kind of reschedule, deschedule, but they haven't really revealed what their studies and research are going to yield for us as consumers and lawyers in the industry. So that's a bit of a TBD. For your purposes, what you need to know today and going forward is that unless and until we have a change in federal law, cannabis is still federally illegal. However, we do have a bright spot with the passage of the Farm Bill back in 2018 when Trump was president. It legalizes industrial hemp and it removes hemp and hemp derivatives from the Controlled Substances Act. So that's a pretty big change. It was significant back then. It remains dynamic today. And essentially now hemp, it's as defined by federal law in multiple states, cannot have more than 0.3% Delta-9 THC. If it does, including its derivatives, right, CBD and the other cannabinoids, it's going to be considered cannabis and therefore federally illegal. Also, with this federal framework, the USDA is the main regulator in play for our hemp cultivators, but it stops short at having regulation for cannabis products, including hemp CBD and the derivatives. We do not have a federal framework for that, even though the 2018 Farm Bill legalized hemp and all of its derivatives. Importantly, also, while states can have their own laws that are stricter than federal law regarding hemp, they cannot stop interstate commerce. So that's another big difference between hemp and cannabis, is that we have free movement within our state borders, and no state or Indian tribe, for that matter, can try to prevent that. Last little tidbit, and then I'll let our panelists kind of take off with some initial questions that we've prepared, is that the final USDA regulations for the 2018 Farm Bill came out in 2021. And generally, they detail the federal licensing framework, reporting requirements, record-keeping requirements, and something we're going to probably discuss today, the testing requirements, disposal of the hot hemp, which again is that hemp that tests above 0.3% THC, and then other general compliance provisions. So the long and the short of it is, we've got legal hemp, we have legal hemp derivatives, we have no federal framework for those derivatives to control them, or check on things like quality assurance or testing. We do have it for hemp cultivators and producers. And of course, and I'll go ahead and launch into our panelists, I'll start with Vince, the Farm Bill did change hemp import and export. And I'd like you, Vince, to tell us and our listeners how that happened, what's going on with it, and the current status of import-export for hemp and hemp derivatives.
Yeah, happy to. Okay, so hey, thanks everybody. Thanks for showing up. I can explain that. First, I would like to give a brief disclaimer, which I always give, which is that regardless of what the Farm Bill does or did, you still need to comply with U.S. export control, sanctions, and customs laws and regulations. And the reason I give that disclaimer at the outset is that a lot of the time people come to us with this notion that they'd like to export hemp and they think it's as simple as dropping it into some sealed turkey bags into a DHL box or whatever, and it's really not. There's a whole regime of regulations to consider and protocols to comply with. Another thing I would say is that it's really clear, at least to me, that imports and exports of hemp and hemp-derived products, such as CBD, are more likely to be stopped or seized, at least initially, by CBP, that's Customs and Border Protection, than other classes of goods. And that's true even if you're totally confident that you're on the right side of the law and what you're shipping is totally legal, just good old hemp flower, right? So to avoid unnecessary delays or compliance issues, even if you're very confident you're on the right side of the law, you should ensure that your hemp seeds, for example, are accompanied by all required documentation that includes phytosanitary certificates and that you can satisfy all other applicable CBP import-export documentation requirements, manifests, certificates of analysis, which is testing essentially, etc. And when you get into muddier categories of products, which I'll get into in a second, an opinion letter from counsel is a good thing to have at hand as well. We've worked on these for some very high profile shippers for very interesting categories of cannabis goods. So I guess if you want to draw a really bright line, and the next thing to understand with respect to what the Farm Bill did is that here's my bright line. If something is hemp or is a cannabinoid that is naturally derived from or expressed in hemp, like CBD, those cannabinoids should be permissible for import export as long as they don't exceed those delta 9 THC levels that Hillary mentioned. We have helpful DEA statements on this in the delta 8 context, for example, as well as at least one court ruling in the Ninth Circuit on that same cannabinoid. If you want to go on the other side of my bright line, if you're talking about a synthetically derived cannabinoid, such as THCO, whether that's delta 8 or 9, or HHHCP, or any of these newfangled cannabinoids that just seem to be introduced into commerce every couple months with people bending around molecules at the end of chains and such, then DEA's position on that is all of those are flatly illegal, right? Those are controlled substances. And you get into some kind of funky analysis about, well, synthetic's not really defined and such, but I would say that you're pushing it beyond where the law can comfortably be pushed, especially if you're trying to do something as exotic as export these things. So you're risking seizure by CBP, but you're risking more than that. You may be risking felony charges and such. Proceed with extreme caution. The other thing to understand is that even if you want to hang your hat on this DEA statement with respect to the legality of a product like hemp-derived delta 8 or the Ninth Circuit ruling that I mentioned, that particular product, along with hemp-derived cannabinoids, is not legal in many states. And Hillary also kind of alluded to that, right? States have made their own laws. With delta 8, for example, last I saw it was flatly illegal in some 14 states, even if it's derived from hemp. And the law was unclear in several others. So you've got some risk in even getting these probably federally lawful products to a port of entry, right? That's not the case with raw hemp, by the way. Hillary mentioned that the Farm Bill allows states to opt out of production, but they aren't allowed to interfere with shipments of hemp, raw hemp materials across state lines, okay? Now we get into this issue of quote unquote marijuana. Hillary talked about how marijuana is a federally controlled substance, no medical use, et cetera, et cetera. The Farm Bill exempted hemp from that definition, gave it its own definition. Shipping marijuana, like, just the kind of stuff you may walk into a retail store and buy in one of these many legal states, is a really, really hard thing to do, almost an impossible thing to do. Cultivation or purchase of marijuana or possession of marijuana is only really allowed for research purposes at the federal level and requires a DEA registration. Now, there have been some imports of marijuana into the U.S. by big companies. I know Canopy had a press release on it a few years back. It was kind of interesting. They imported from Canada, a country with federal legalization, and they did it through a DEA license. They had to have the substance. But I would just say generally, if you're a U.S. company and you want to import or export actually like marijuana flower, finished marijuana goods? Probably not. I mean, if you're in Canada or if you're in one of these other countries, Israel's always been a big cannabis exporter. You may be able to partner with a country that's always been a medical cannabis importer. Germany is a big one. There are a few other ones. But I think from the US, it's just an awfully hard thing to do because really you're only supposed to have possession of the stuff in the first place for medical or scientific purposes. You get into a really interesting question here, though, with respect to what the Farm Bill did on seeds. So a question that was asked by an attorney, that's a friend of our firm named Shane Pennington to DEA a couple of years ago. I think he asked the question by letter in late 2021, and he got a response in January of 2022, is, are quote unquote marijuana seeds legal? So I'm talking about seeds that are, produced by some mother of, people breed these things for bonkers levels of THC these days, right? Like a 40% THC plant. Is the seed of that plant legal? Is it hemp? Is it now? Because if you read the literal definition of what hemp is under the Farm Bill, you might say, yeah, I think it is. And to a lot of people's surprise, DEA said, yeah, we think it is, right? This DEA official wrote back and he said, well, like that seed doesn't have above 0.3% THC, Delta 9 THC on a dry weight basis. Therefore, it fits the statutory definition of hemp and not marijuana. Now, when that seed germinates and grows up and flowers, it becomes marijuana magically. It's just kind of a legal construct. But the seeds themselves, I think you can take a good faith position and what we call a reasonable care position for export analysis, that those are not controlled substances. And that's another thing we've worked on. In cannabis, genetics are the name of the game, and these big companies want to send their seeds all over the world for their far-flung outposts and these things that they're doing in other countries. And we've been working on those projects, and they're very interesting projects. So that's kind of where I'd leave it. That's the taxonomy of hemp and marijuana import and export. And I hope that was a good enough high level for you.
I think it was. And seeds have always been very interesting because feminized seeds incapable of germination into full-blown cannabis plants never really caught heat. And now we have this expansion because of this somewhat arbitrary definition of hemp. And we all know there are tons and tons of marijuana seed companies out there internationally and domestically. And moving on into this more international law cross-section, because I think cannabis companies, even the sophisticated ones, they have a tendency to forget that there's this cross-section of existing law with their very disruptive, innovative, always changing cannabis regulatory frameworks, combined with the hesitance of the federal government to do anything about it. And even our clients that are not in cannabis, once we hit international borders, totally different game about the international law implications, even from country to country, obviously. So I want to turn to Fred and ask, what is, and this is such a generalized question, so feel free to kind of distill it down into what you believe is relevant. What's the status of cannabis, hemp derivatives under public international law? And really what I'm thinking is single convention, the one that murders everybody, that we imposed on everyone, that's seemingly unchanged, although there may be guidance that there are changes, practically speaking. What do you think, Fred?
Sure. Well, let's start there. Let's start with the single convention, formerly the Single Convention on Narcotic Drugs, which was signed in 1961. And this is an international treaty that regulates activities involving certain drugs. It's one of these international conventions of the type that international bodies like the UN propose, and everybody signs up for, perhaps not really thinking that it's going to account to much in a practical way. But cannabis and cannabis resin were originally scheduled in Schedule 4. And just a quick note, for those of you who are familiar with the Controlled Substances Act, the single convention goes the other way around. So Schedule 1 is the least serious, and it goes all the way up to Schedule 4. So cannabis resin were scheduled down from 4 to Schedule 1. This was in 2021, following an assessment by the WHO that gave the green light to this. Extracts and tinctures are also included in Schedule 1. There is disagreement as to whether CBD should be considered scheduled under the single convention, and if so, where it should be scheduled. But even in the context of domestic law, these legal debates can sometimes be a reflection of views by persons that ultimately don't have practical consequence. And in the context of an international law like this, that could be the case even more so. There's a separate agreement, the Convention on Psychotropic Substances, dating from, entered into in 1971. This convention lists THC, which at the moment is in the second strictest level, and I don't want to keep confusing people further. And this convention actually goes in the same order as the Controlled Substances Act, but suffice to say, THC is in the second strictest level of scrutiny, although Delta 8 and other isomers are continue to be in the most restricted category. Final thought, as some members of the audience will know, enforcement of international laws can be patchy, even in countries that signed up for these conventions. There are exceptions, of course, but a lot of countries will tend to give their own domestic laws primacy. However, one practical consequence of the existence of these international agreements has been the fact that some countries have considered them to be obstacles on the road to legalization. In some cases, that might reflect the good faith effort to comply with international law obligations, and in some cases, it might just be a convenient excuse for those who would rather not legalize.
Okay. And just to get a little further into the weeds, because it's relevant, we have to deal with it here in the States. What is, and I'll direct this to Adams, what is the Controlled Substances Import-Export Act, and how does it interact with this bizarre democratic experiment / the 2018 Farm Bill?
Well, the Controlled Substances Import-Export Act basically sort of overlays on top of the Controlled Substance Act a trade aspect to it. Basically, if you want to trade, import, or export a controlled substance, you need to get the blessing from DEA. And so it is possible to import and export controlled substances, but you have to go through the whole rigmarole of applying to DEA to get the permits. And so essentially that has become a hard barrier for most companies because you have to jump through so many hoops to satisfy DEA that you are a competent company that can safeguard a controlled substances along from start to finish of the supply chain. So effectively, even though the Controlled Substance Import-Export Act did authorize imports and exports, it's such a limited exception that it's effectively a hard barrier to basically 99% of the companies out there. So usually in terms of talking about import-export, it's really, if it's a controlled substance, if it's above 0.3%, it's a no-go. So now everyone is basically looking at, okay, we want to import legal substances, something that is below 0.3%. So if we find that product, what can we do with that? But that is the big question. Is CBP or any other customs authority around the world, are they going to agree that your product is legal, that it is not a controlled substance? And that's really a lot of our issues in terms of trying to get the governmental authorities to sign off and say, yes, this product is okay to import and export. And that's kind of where the battles are being fought right now.
Yeah, and it's an interesting battleground with all of the things they consider to determine legality, and we'll get into that. It's way more than just, does this substance contain more or less than 0.3% THC. I want to move on to paraphernalia, which is a huge industry, right? Been around forever. And anecdotally, we had a client many years ago, and all they did was make pharmaceutical bottles. This was back when medical cannabis was the only way to access any kind of cannabis under state law lawfully, and they were never plant touching. They only moved plastic, traditional, white bagging type prescription bottles. And of course, back then, that was attractive for cannabis patients to have their cannabis in those bottles. And one of their shipments was seized and detained by CBP. and they were shocked. This had never occurred before. It was about $100,000 worth of inventory, and they inevitably had to forfeit the bottles because they met the definition of paraphernalia under federal law, which is very broad and unforgiving and unimpacted by these state laws that otherwise support their sale and even use. So going to paraphernalia at this point, Fred, what's the status with import export there? Is it the same? Is it still draconian, or exceptions being made if it's hemp or hemp derivatives? What's your take?
Sure. So the starting point for any discussion about this topic is the federal statute on drug paraphernalia, which, among other things, makes it unlawful to import or export paraphernalia. So that's the black and white law that's on the books, and we can say that generally, as you pointed out, Hillary, the definition of drug paraphernalia has been very expansive and subjective. And what we have seen over the past few years is actually CBP going into social media, digging into Amazon reviews to try to make that connection between a particular product that's being imported and cannabis. And it's not that hard to find those connections when the products are in fact used in connection to cannabis. This is not just a CBP issue, by the way. We see, for example, in the trademark context, USPTO will also enforce or look to enforce these laws as it sees fit. And again, there's this very subjective approach. However, things have gotten interesting in the past year or so, and this is because of an exception to the general rule. And that exception provides that the prohibitions that are in place when it comes to drug paraphernalia shall not apply to any person authorized by local, state, or federal law to manufacture, possess, or distribute drug paraphernalia. This is not a new argument. This has been tried in the past, where basically importers said, "Look, there's a clear exception under the law." But generally, up until now, the CBP primarily has not been receptive to this argument. The thinking was, well, that exception is really there to cover situations where law enforcement might have might have drug paraphernalia for whatever reason. Interestingly, there's no legislative history when it comes to this particular language in the statute. And if you look at there's a Department of Justice manual from 1991 on the issue of drug paraphernalia, makes no mention of this. So clearly this was not something that the federal authorities were ever worried about. And perhaps they just didn't imagine that there would come a time when states would begin to legalize cannabis-related activities and provide this line of reasoning. A couple of big cases in 2022, Eteros and Kirtan. And to summarize what these Court of International Trade cases said is, they both involve Washington State. They said, look, Washington State has changed its law to authorize activities involving drug paraphernalia. That constitutes authorization as provided for in federal law. And there's, we're looking at the clear, unambiguous language of these laws. And there's really no way around it. One of the lines, one of the quotes in Eteros, citing another case, which is a bit of a breath of fresh air, depending on where you stand on certain issues, says that courts must presume that a legislature says in a statute what it means and means in a statute what it says there. So basically, you have the Court of International Trade saying very clearly, blatantly saying, if this is not what what Congress wants federal law to be, then they need to change the law. But as it stands, we're going to interpret it in this way. In those two cases, they allowed the importation of paraphernalia, and it's a very positive development. This said, CBP continues to detain and seize drug paraphernalia. So for importers, the message that I would impart to them is this is Eteros and Kirtan are very interesting precedent, but it's you might need to fight CBP on this. We don't see any indication of CBP just rolling over and starting to let paraphernalia come in. So it's a positive development, but in the sense of giving importers a fighting chance.
And Adams, let's talk about the Customs Modernization Act, because it obviously plays into this new development with hemp and hemp derivatives. How does it affect potential shippers in the space, and what is it?
Yeah, the Customs Modernization Act basically changed the way customs handled all the import transactions it sees. I mean, it's not like we're in the 1700s where customs could actually check every import shipment coming in, and the volume of shipments is just so overwhelming, so that customs appropriately recognized that they no longer had the resources to effectively review every shipment coming in. So they placed the legal burden on importers to lawfully declare their entries, to make sure that everything is declared accurately in terms of how it's classified, the valuation, country of origin, all these good things that you fill out on an import entry form. And the legal standard is, is the importer exercising reasonable care? And the customs places the legal responsibility on the importers to exercise reasonable care and making sure that everything is correct when they make a declaration. So when you come in and you're declaring something that could be drug paraphernalia, are you exercising reasonable care in importing that product? Now, you could say, hey, look, I've got these great CIT decisions that says, hey, Washington State, where I'm delivering this product, says that it's legal, but CBP may still disagree with you. And that's what we're still running into, is that at the federal level, CBP is still kind of working its way through this process. They could limit the impact of these two CIT cases just to the particular facts of those two cases that they reviewed. And what we've seen, not just for drug paraphernalia, but for any product that customs looks at, there's usually a process that takes a while to work its way through before customs recognizes what is the new scenario here. So in terms of defining what is legal drug paraphernalia, depending on whether the states have authorized it, I imagine that there's probably going to be a good some lengthy process to work itself through customs, and likely is going to need some appeals up to the CIT as well.
And what about the commerce control list and export control classification numbers? Are cannabis products covered between those?
Right now, flipping over to the export side of things, cannabis and all the derived products, at this point, they are not on the controlled list there. Control list is usually for like weapons or high-tech stuff, or munitions, chemicals, sensitive stuff that they want to keep tabs on where it's going, when it's being exported out of the U.S. So at this point, cannabis products are not, but that may be in part because everyone thinks that the controlled substance, the convention covers drugs. So that may be why it's not, on the controlled list there.
Got it. And given the distance between state law, the feds, and then CBP is its own animal relative to these issues, can you request a ruling from any federal agency related to any of this at all?
Yeah, I think we can look at CBD and hemp. We have seen parties go into customs and ask for rulings to say, is this admissible? And if so, what's the tariff classification? And customs has actually issued rulings on that. So, you know, at some point, we're hopeful that customs will eventually make rulings on like hemp flower or some of the products that are kind of in that gray area right now. But we are seeing that customs has been a little bit reluctant. They're dragging their feet on some ruling requests. Ideally, we will see customs make rulings that further clarify which products are or are not legal. But again, that's likely going to be a process that it does seem that CBP is waiting for guidance from other agencies. You know, the CBP coordinates with all the other federal agencies, and I don't think CBP wants to be out in front of this issue as to what is legal or not. And so it seems that they're hoping to get other agencies to weigh in and help them out, and that doesn't seem to be happening anytime soon.
And
one thing I could say, if I could just tag on that, is he was talking mostly about export there. It seemed like CBP did publish guidance shortly after the Farm Bill passed about importation of hemp seeds and hemp plants. And you can go read that on their website. I mean, you need a phytosanitary certificate and a seed certificate, some other type of application. That's on the import side. So I want to be clear that it's a different analysis coming and going. Sorry to cut in.
That's all right. I was going to ask Adams, you know, the rulings sound pretty good. Whenever you can solicit a positive response from an agency of any kind, local, state, federal, clients love that because they think they've got some kind of official opinion. Sometimes they do, most of the time they don't. What's the downside of getting a ruling, Adams?
Careful what you ask for, because if you ask the question and you get the wrong answer, even if you know that the government is making the wrong answer, if they answer no to your question and you don't want that no answer, you're stuck with it, at least for that particular ruling. So that's the huge downside risk that a lot of companies are, you know, reluctant to pull the trigger on making that ruling request.
And with some of that ruling request, does it depend on how you word the request? I imagine it does, because I know from the regulatory perspective, when we interact with state regulators for the cannabis side, it definitely matters how you phrase the request to avoid ambiguity, to avoid getting an answer you don't like. Is it similar to that, or is it just always a crapshoot anyway?
Oh, absolutely. Yeah, no, I mean, to a certain extent, there's a crapshoot, but to the extent you can frame the facts, the legal framework, the analysis, you can certainly make a stronger argument as to why your outcome makes more sense than the way they may be looking at it in the opposite direction. So definitely helps to have someone work with you to kind of figure out what is the best way to present this to maximize your chances of getting a favorable ruling.
And what's standard timeline on getting a ruling, good or bad?
Ideally, customs can make a ruling within a month, 2 months, but there are no hard deadlines. So customs can and has extended the deadlines sometimes indefinitely. So, you know, you can hope for a quick response from customs, but you can't bank on it, that's for sure.
And is there a scenario where they just never respond at all? For example, do they have to get back to you at some point dictated by statute, or they just never have to respond if they don't decide to?
Unfortunately, no. I mean, we've got ruling requests we're looking at. We're at year 2 already on waiting for a response. So unfortunately, there is no hard deadline that you can hold customs to.
Got it. Okay, makes sense. And then Vince, back to the states, because obviously that's relevant here, especially with the differing ports of entry. What are some state law implications to think through if you're going to import or export?
Sorry to unmute. So state, yeah, it's interesting. A lot of the states with regulated cannabis programs on the marijuana side right now I'm talking have seed to sale tracking and like four corners type rules, which is to say that if you have a seed that starts out in their program, it's got to stay in their tracking system all the way through germination or whatever happens to it, destruction, and you can't move it across state lines. Even if, again, it fits that sort of farm bill statutory definition of hemp, perhaps it's a seed with no THC in it. The state still will say, well, you can't, take it out of the system, or you're out of compliance with the state law, and you could lose your license. And that can be a problem for bigger companies that have developed all sorts of genetics that they really, really like in certain states, but then they say, well, how am I able to get these out of the state? And, certain states have, I guess, like magic source rules and things like that, where they don't really question where seeds came from, if they came from over state lines and things like that. But when you get into ideas like export and you want to say, move a bunch of seeds out of, I don't know, Hillary's in California, we could use that as an example, or I'm in Oregon, we could use that as an example. You're not allowed, I don't think in California, I know you're not in Oregon, to just sort of pull these off of your seed to sale tracking platform and put them in THL box and ship them to wherever you want to ship them. And that's a hard thing for companies which may have multi-jurisdictional approaches to commerce. So that's the biggest state hurdle right there.
Got it. And then for our US exporters, because they're beginning to pick up in number, what are some destination country issues to think through? And again, our firm we also have a very robust international practice, and it seems like anytime we have third-party manufacturing agreements or anything where parts are going to traverse country borders, it's similar to what we have with the states, which is every single one is different. Fred, what do you think about that?
Sure. So in terms of things to consider, the first one is really the legality of cannabis. I think there are, as Vince was mentioning earlier, there are these misconceptions sometimes about what a particular change in the law really means for industry participants. So thinking back, for example, to when Canada passed the Cannabis Act, I remember there was a notice sent to every household in Canada, making it very clear that just because something was just because of that legal development in Canada didn't mean that you could just walk across the border into the U.S. with cannabis or vice versa. Yet people continue to get in trouble because they don't understand that. So that's the first thing. Make sure you understand what really is allowed by the laws that are in place, right? I mean, obviously, in most cases, the fact that you're looking at a particular jurisdiction will probably be the result of some legal development there that leads you to think that it's possible to import or export from that country. So that's the first thing. Make sure that you understand what the law actually says. Also, just because a particular activity is authorized, it does not mean that anyone can do it under any circumstances. Typically, these activities will require some authorization from a government authority, and that process can be quite complex, and it might not be as straightforward, perhaps, as one might think. So yes, there might be a legal possibility of sending cannabis products to a particular country, but you have to really dig into what's required to get the authorizations. Related to this, there are issues relating to bureaucracy, right? I mean, in any country, you have what's possible according to the legal framework, but then there is that reality of what it means to work with certain government agencies. And there might be all sorts of informal practices that mean that, going along with what Adams was just saying, yeah, there is a process in place to get a ruling, for example, here from CBP, but it might just be slow walked to the point where it's there's no practical value to it. Same thing might happen in other countries where the law might establish a procedure, but that ultimately has to be implemented by human beings. And in that sense, it's always important to keep in mind that the theory might in fact differ from practice. Also, following up on something that Vince said at the beginning of the presentation, cannabis laws are one thing, custom laws are another. Each country is going to have its own requirements governing import and export, and you have to make sure that you're complying with those laws independently of what the subject matter is. Here in the US, for example, you have to make sure that you are properly evaluating products. You have to make sure that you're using the right codes to bring in products. The same applies to other jurisdictions. And finally, especially keeping in mind the nature of cannabis products, phytosanitary regulations. Countries typically have many countries have robust frameworks in place to make sure that products that are coming into the country are safe and are not going to destroy their crops. And in fact, some countries might not have particularly well-developed frameworks for controlling imports, but they might have very careful rules when it comes to agricultural products because of the nature of their economy. So these are the things in general that you'll want to be looking at.
Fantastic. We did get an audience question that made me chuckle because it's also how my brain works, and I love the question, which is, which ports investigate the least sea freights? And bigger than that, can you shop port of entry to try to get this through because one may be more lax than another? And given that we live in a democratic republic, maybe a California port, like the Port of Long Beach, is friendlier than, let's say, I don't know, somewhere in Texas.
Theoretically, you could port shop, but I think the way customs has evolved here, everything is centralized, and so the good old days of port shopping are probably, it's very rare to find that kind of advantage of identifying, say New Orleans is far better than, Long Beach or New York or anything like that. I just don't think that's happening. CBP has established these centers of expertise in which they have product groupings where they have personnel that are experts in that particular product or industry area. So they don't have one officially that covers cannabis, but I think it's a matter of time. They are going to have personnel who are probably related to some type of agricultural product and are going to be more familiar with cannabis, given their backgrounds. And so they will have expertise, and their expertise is going to be applied uniformly across all ports. That said, the treatment by CBP on individual entries will depend on the customs official that handles your entry. So some are going to be more aggressive than others. Some will feel that, hey, I think this is drug paraphernalia. I'm going to go ahead and detain it or seize it, or I'll even just ask for an inspection just to cause a little trouble here. So it does depend a little bit on which individual customs authority, but can you shop for a port that has less of those types of officials? It's going to be pretty hard to find. I wouldn't recommend searching for that kind of that experience there.
Okay, and moving on to assistance here, how people do this. Obviously, there's so many pitfalls and trappings on both the cannabis compliance side and then the entirely separate world of trade and customs from country to country for both importers and exporters. Now, back in the day, I used to bag on attorneys that wanted to be cannabis business lawyers that were doing it all. They were doing litigation, they were doing trademark, they were doing constitutional law, they were doing compliance, they were doing licensing. I still take that position, that that's a bad idea for a number of reasons. But I'm hard pressed to believe that a lawyer just doing cannabis could somehow flip into a trade lawyer or a customs lawyer overnight to handle these things. So Vince, as the cannabis business attorney on the panel predominantly, and I know that you've helped both Fred and Adams as customs and trade attorneys in this arena, what role does the attorney play? And could one lawyer do it all without disaster?
So the answer to that last question is very definitely no. I like to think of myself as a sort of accomplished cannabis attorney, and I should not be meddling in the trade space without the assistance of people like Adams and Fred, who've done this trade stuff for a long, long time. And just, I mean, there's just things I don't know what I don't know. So I'm happy to pitch in on that stuff. But yeah, you need a trade lawyer if you're going to do this stuff. What can attorneys do to help? Well, I mean, obviously we can analyze the state of the law with respect to any category or product of category in this space, right? That's bread and butter stuff for attorney. Beyond that, I think Adams mentioned earlier that you've got to quote unquote exercise reasonable care, and that's a term of art with respect to the import and export of any category of good. Well, how do you do that? It's not enough, I don't think, to say, hey, CBP, I went on hemphero.com and found a blog post that says I can do this. And by the way, I don't even know if that's a real site. And if it is, I apologize. I'm not trying to get on hemphero.com. But it may be enough or persuasive for you to have an opinion letter or some other statement of counsel with respect to what you are seeking to do, right? That's a really powerful arrow to have in your quiver. And then attorneys can kind of go through and analyze things like, you know, ports of entry. Yeah, somebody asked a great question. Can you shop them? Adam's great answer on that. And there's just like a miscellaneous like plethora of questions, a knowledge base that we draw on to help people with this stuff. So that's my pitch.
Right on.
Yeah, the other thing with that is that, you know, attorneys are probably better equipped to know how the government side of things operates. So knowing who to ask, you may not know off the top of your head who to call, but you have a better idea of someone in CBP who can point you in the right direction. So it's also, CBP is going to be asking questions that they may not really know why they're asking those questions. And so trying to, you know, work with CBP to figure out, what are you really asking? What do you really need to know to make your decision? And so you become the interface to sort of assist the customs officials to figure out, you know, what do they need to make the decisions that you want, right or wrong, and then trying to figure out where in the supply chain you can get that information. CBP is going to ask a million questions, and your client may not have that information. They need to ask their supplier or their customer, or their broker has some of the information. You know, so trying to work with customs and all the parties involved in the supply chain to figure out where is that information that is needed.
Yeah, similar to the IRS, it seems like CBP is not an agency where you just want to wing it or go alone for a number of reasons. And what I want to do now, within the last 10 or so minutes that we have, I want to kind of go through rapid fire audience questions that we received prior to the webinar, because these are going to go to, I think, the more practical implications of actually doing this and the nuts and bolts of what's required. So one question that we got was, what testing is required if you want to export from one country to another? And it's a bit of an unfair question, because we've revealed, we know each country will be different. In the United States, each state could be different if it regards hemp and hemp derivatives. But generally, what testing do you guys think is going to be required for that?
I mean,
Well,
I would hazard to, go ahead, Fred. I was just going to say you need a certificate of analysis. COA is kind of the baseline testing proof that you need from a lab, and there's some big ones and some good ones that test for this stuff. So I would start there. And we've also talked about phytosanitary certificates and other things on different sort of classes like seeds. But go ahead, Fred.
No, just to picking up on the themes that we've been discussing, especially in the context of working with officials. You really want to be very focused on what the countries in question are going to be asking for. You know, you can take your products to a particular country and show up at customs and say, hey, listen, this is what I got. And they might say, well, this is not good enough for whatever reason, right? This is one of the many reasons for having trusted counselors in not just your jurisdiction of origin, not just in the place from where you're exporting, let's say, but also in all of the countries to which you're importing, the people that can say, okay, this is what they're really going to want. This is what they will accept this is what they won't accept, right? So it is really going to be a very jurisdiction specific question, not something that lends itself to broad generalizations.
Right.
Yeah, some countries ask for COAs where some countries have THC limits that are at 0.1%, right? US is at 0.3%. So, which one do you want to test to? If you can satisfy 0.1%, you're going to be able to satisfy 0.3%, but you can't go the other way around. So, you make the decision as to where you want your testing to go.
Right. And it may not be as intense as we see with the states that require all kinds of testing, from microbial contamination, hard metals, toxins, you name it. The states put the cannabis companies through the ringer. It may not be that robust, but I think if it was a standard COA, you're going to see some of those things on there anyway. And then another good question, and we've gotten this question before over the years, and maybe it's a bit of the same answer, but between importers and exporters, how can they trust each other that they're not going to traffic in a controlled substance at any given moment? Because of the dynamism of the product, the fact that you've got hemp seeds that can germinate into cannabis. And, Vince, we can talk about this a little later before the conclusion of the presentation, but these are the cannabinoids that may not contain 0.3% THC, but on conversion with combustion, definitely contain more than 0.3% THC. How are they going to trust each other in these marketplaces, crossing borders?
Well, really the issues here are the same ones that you're going to have with any other international transaction. And the reality is that these are real risks, right? I mean, when you engage in transactions with anyone, but especially someone in another country where there's a different legal system, where there might be a different business culture, these are going to be risks. And building trust is not easy. And certainly not, again, across borders, across language barriers, across all sorts of barriers. So I would say the first thing that comes to mind is to apply some of those fundamentals. If you want to engage in business with someone to the extent you can, go visit them, go visit their facilities, make sure that what they're telling you lines up with the reality that you see on the ground. And in fact, I would say some of these practices might even be more important in some other cultures. I think this is very sort of, very informal analysis, but probably here in the US, we're one of the places where, depending on how you look at it, good, bad thing, people are used to doing business with strangers. We have a robust legal framework that kind of allows you to take certain risks, but in other countries, for whatever reasons, people are going to expect or will want to have more interactions, that they're going to want to feel that they know you, they're going to want to break bread with you, have those in-person conversations. And again, as they said during the Cold War, trust but verify. You shouldn't, you have to be careful against being exceedingly skeptical, because otherwise there will just be this sense of paralysis that will not let you enter into many transactions. But that doesn't mean you should be foolish. And Hillary was pointing out to the fact that sometimes participants in the cannabis industry and other industries, they just forget that once you step outside of our borders, it's a different world out there. And this is something that I certainly see in my practice. The same companies that will be very cautious about entering into agreements and deals within the US will sometimes just throw caution out the window when they go overseas, when in fact that's when they should be more careful. So that would be, for me at least, a starting point. Go back to the fundamentals of building reliable business relationships overseas.
Yeah, I think the long and the short of it is diligence your partners, right? Ask the basic questions about their facilities, their practices, most importantly, their enforcement history. Do they have a compliance team? Do they have an officer that deals with import-export? Those are going to be the highlights of meaningful diligence, not some kind of, as Fred would put it, overly skeptical exercise if you really want to do business. But due diligence is part of this too. Don't just trust the COA that you're getting. Know your partners. And I think that would go for any relationship with any kind of international component relative to import-export. Another hot question, and Fred, I'll direct this to you because I think you may have the most knowledge on it. From the US, or even beyond the US, what countries are engaging in import-export that you've seen lately in cannabis/hemp?
Sure. So, I mean, obviously, with the caveat that we are, all of us on this call are U.S. lawyers, and whatever we see overseas is through the lens of our partners overseas and persons who are interested in the industry. But for example, I mean, I think it was brought up earlier during the presentation. Israel is a country that has a long history of cannabis research and development. And I was just reading an article not long ago that basically there is so much cannabis has been exported into Israel that it's just destroying the local cannabis industry, just because there's so much competition from overseas. So that's obviously not good for local growers, but clearly there's that indication that it's there's a market there. If you look, for example, at Canada, you're going to find language that's actually not that different, at least on the surface, as that we have here in the U.S., right? I mean, it is import and export activities are allowed, medical and scientific purposes. You have to get authorization from, again, my perspective as an outsider, it does seem that it seems to be a system that does deliver more in terms of actually issuing authorizations. Seems here in the U.S. it's sometimes more of a theoretical thing. And in Europe, there's a lot of activity to service some of the medical cannabis markets, such as those in Germany, Spain. We do a lot of work in Spain, and growers that are licensed by the government can export. Other countries, I mean, I could go on and on, but Lesotho in Africa is a country that is well known for exports of cannabis. I believe South Africa has also followed in its footsteps. So a lot of potential combinations out there. But again, bottom line is, whatever framework there is for import-export is going to, of course, be bound by what's legal in that country and what isn't, right? So just as we get many questions from people interested in sending their products to the US, we have to always go back to that fundamental issue of legality. It's going to be the same overseas, right? So what does the country authorize? And then how are those needs met? And then you can start putting together the connections there.
And do the three of you think collectively, individually, that the international cannabis trade is going to pick up in the years to come in the future, not just in the US, but across the globe? And why, I suppose?
I do. I mean, I think we saw some changes under just good old public international laws. Fred highlighted pretty recently, loosening up some of the strictures on cannabis classification. We see countries, one after the other, sort of loosening their restrictions with respect to domestic cannabis policy. And when you get a couple of countries, say Canada and Germany, that are, federally legalizing cannabis, they're going to say, yeah, of course you can export/import a federally legal product. So I think that's the trend. It's not super fast. International law, in my experience, tends to move a little bit slowly, even glacially sometimes on certain topics, and it certainly has with cannabis. But it's a lot different sitting here right now today than it was 3-4 years ago. And I think you're going to see further dynamism as soon as this fall with respect to US policy. I wanted to just throw a caveat out there that they have to redo the Farm Bill every 5 years. And some of the stuff I said on certain cannabinoids earlier and such may not be the same 3 or 4 months from now. So if you're one of these people watching this thing on YouTube, by the way, this webinar stated July 25th, 2023. Don't take what I said about certain cannabinoids as true 6 months from now. So yeah, I think it's changing and changing quickly, and I think you'll see more and more import-export as the years go by.
Yeah, I'd agree too, but I'd caution that as international trade grows, there's likely going to be these competing pressures. Fred mentioned Israel, where the local Israeli growers are getting swamped by imports coming in. And most countries in US, European, EU have trade laws that allow domestic producers to ask for tariffs to be imposed on unfairly traded imports. So I think if and when international trade of cannabis products, takes off, I would bet that there's likely going to be some domestic industry around the world that is going to file a trade action asking for help to protect themselves on the onslaught of imports coming in. So Canada right now is kind of like the leader in terms of legalization, and they probably have a head start at exporting out around the world. But if and when the US opens their border, I imagine the US growers would likely be quite fearful of the potential flood of imports coming in that could squash their industry before it even takes off in terms of import competition.
Got it. All right, gentlemen. Well, we're at time. I want to thank you all for your contributions.